We begin this afternoon with stunning new developments in the case against the parents of the Oxford High School shooter. Thank you for joining us today at 5. I'm Glenda Lewis.
And I'm Brian Abel. Today, the state's highest court ruling that further review is needed to see if charges are warranted for the couple. The court saying a review of the charges needs to be done by the State Court of Appeals.
James and Jennifer Crumbley are each charged with 4 counts of involuntary manslaughter after their son killed 4 students at Oxford High School on November 30th last year.
7 Action News reporter Simon Shaykat shows us how families in Oxford are responding.
After learning of a delay in the case against Jennifer and James Crumbley here in Oakland County, the Oxford community has not stayed silent. In fact, some are expressing anger. It's a critical decision the Michigan Supreme Court has made that's left many families in Oxford speaking out in opposition, as Jennifer and James Crumbley, parents of the Oxford High School shooter who killed 4 students and injured others, remain in jail. The court has tasked the State Court of Appeals to rule on a major issue: whether or not there is sufficient evidence for them to stand trial for involuntary manslaughter.
We're really emotional. It's a lot. You don't know how we're supposed to navigate this whole thing. And then to have part of it done, like we have the first part, the shooter part over, it felt like we weren't very far from the end of the second part. And now to know that we don't really have a timeline is painful.
Stacy Broder is a parent disappointed to learn of yet another delay in a case that was slated to start in January. Another parent, Lori Bourgeau, says her son Mason was close by as bullets were being fired a year ago, and the parents of the shooter must be held accountable now.
I feel like the prosecutors know what they're doing, and they've put a lot of time and effort into this, and I do believe that it will go through.
Agreeing with them was Michigan Supreme Court Justice Richard Bernstein, who issued a dissenting opinion that this would amount to a needless delay, adding these issues are, quote, more appropriately considered after trial if necessary. In the meantime, attorneys on both sides have declined comment. The Crumbleys are accused of gross negligence in allegedly buying their son a handgun and ignoring his mental state, while his lawyers have argued they had no reason to believe he posed a threat to himself or others. Coming up at 6, a closer look into how the 1-year anniversary of the tragedy is playing into the feelings families are experiencing now. From Oakland County, Simon Shaykat, 7 Action News.
The state Supreme Court sent the Crumbleys' case back to the Court of Appeals to review one issue, and that issue is causation. I spoke with attorney and former Assistant Wayne County Prosecutor Todd Flood this afternoon about what this pause to consider causation means.
Did the Crumbleys cause, or were they a cause of the deaths of 4 people dying? So that causation issue, all they have to do is show it was a cause because they were the ones that supplied this gun to this child that's in crisis, that obviously any reasonable person could foresee that something really bad was going to happen, and it did. And on top of that, the evidence showed they saw the gun that they got for their son or supplied in a terrible way, the pictures of him drawing blood all over the place. When they went to the school, they refused to take him knowing he had a gun.
So with Justice Bernstein being like the one who was in dissent of this, is this being perceived as a break for the couple?
Yeah, I mean, obviously, right? They get a bite at the apple to go, expand the record in the Court of Appeals to say that the record didn't reflect that the prosecution showed causation.
So this will just be time to vet it all out.
That's right. Yeah. There's going to be some safeguards, some bumpers here in place, but it is for now a pause for the defense to appeal in the Court of Appeals and see what they do. But I think the evidence is strong enough right now at this time, but we'll see.
So the Court of Appeals will review this, and as Attorney Flood went on to say, there are unfortunately more cases in which parents have been charged with involuntary manslaughter for even less involvement than the Crumbleys. Some of those will be argued and considered in this review.